Learning the law versus learning to be a lawyer. What are the top 5 differences? I believe them to be in categories of the client, drafting, the environment, collaboration, and responsibilities and mistakes. I'd like to address each one of these individually and flush out the main differences between being a law student and practicing law in the real world. When you're learning the law versus learning to be a lawyer, one of the biggest differences is the client. When you're learning the law, the client is often created. It comes in the form of scenarios, papers, documents, assessment tasks, or even just reading case law. The client in that situation either is real or isn't real, but you never actually deal with them face to face. The information is always given to you, and you can always refer back to it to complete your task. Everything you need is always laid out easily right in front of you, and it is a lot easier to stop, start, go back and refer to the information when it's already been given to you. However, you never get to meet the client face to face, so there is never any confusion in relation to their emotions or actually having to deal with them as a person. When you're in the real world and learning to be a lawyer, the biggest thing you will deal with on a daily basis is the client itself. A person can be in many different types of emotional states, whether they be happy and elated because they're buying their first home, upset and grieving because they've just lost a loved one, or they're seeking your advice and they're very angry over a property matter, a tort, or family law matter. Dealing with the person themselves and learning your mannerisms can be one of the toughest challenges when you're learning to be a lawyer. Every person is different and every personality is different. Even though you have a duty to the client, to inform, to keep them calm, to ensure that you get the correct information, uphold their confidentiality, and ensure that everything that you give them is accurate and they can make an informed decision, it still doesn't make it easy when you're dealing with someone who can be in a heightened state of emotion. Dealing with somebody one-on-one takes us sometimes, some people, a long time to learn how to do that skill. It doesn't often come naturally, and it is a lot more difficult to deal with a person face-to-face than it is for a created scenario. One of the second biggest differences between learning the law and learning to be a lawyer is drafting. One of the biggest things I've had to learn is the differences between university documents, assignments, and things like footnoting and bibliographies versus drafting in a real-world scenario. Recently, my legal practical placement taught me this in leaps and bounds. It's a lot more different when you're writing an affidavit, a statement of a witness, letters of offer, and all the different types of forms of documents that come from being a real lawyer versus what you deal with when you're in the academic world. In the real world, you don't have to worry so much about footnotes, bibliographies, or referencing textbooks or finding outside sources such as media, campaigns, websites, different forms of books and magazines, etc., to reference and collaborate and back up your work. Whereas in the real world, you pretty much deal with legislation, all different types of scenarios in relation to how the legislation can be interpreted and how you put that down on paper. Every single court has different forms and ways of doing things. It can be quite confusing when you're looking up the websites and you're looking for the Federal Circuit Court, the Family Court, or a Magistrates Court document, depending on what you're looking for. When you're working in a practice, they generally have precedents, documents and settings, pre-made templates, and that often they use programs such as Leap. Those always make it a lot easier for you to draft the scenarios that you need and make them compliant for the courts. However, in an academic situation, you generally don't ever have to submit a real affidavit as an assessment. You have to generally critically analyse, look through your information, reference it, refer back to specific parts of legislation that you're trying to prove your point to ensure that you have actually understood the law and how it is written in the legislation. Whereas in the real world, you're giving your advice based on what the client has told you and generally following their instructions, which makes it a lot more different. Drafting in itself is a skill that needs to be learned, and the academic drafting world is very, very different from the drafting that you do in real world legal practice. Another major difference between learning the law and learning to be a lawyer is your environment. As you can see behind me, I'm sitting at home in my home office. It's the only place I've got a camera to be able to record this. And as much as I would like to be able to fade out my background and have it a little bit more exciting, unfortunately, my computer screen doesn't allow it. It is a lot easier to sit at home in your own comfortable environment, turn up to lectures, to do your materials and your assessments and read your textbooks while you're sitting at home in your underwear, putting your feet up with a pair of slippers or your pajamas and drinking a cup of coffee. It's easy here to eat at your desk. You can yell at the kids while they come in and make noise and come in and out. And it's a little bit more comfortable. You're in your own zone. If you need to get up and go and do things, you can walk out and come back and take off where you left off. In the real world, however, you have a lot more different and higher expectations of you in your office or in your practice. Your appearance and how you present yourself is of the utmost importance. You must look professional, clean and polished at all times. There's certain etiquette that you have to follow, and it's certainly not acceptable for you to turn up to work late or for you to not abide by the court etiquette rules when you're entering a magistrate or a judge's courtroom. So this brings me to my next point of differences, and I believe that to be collaboration. When you're at university, it is generally considered that all of your work be 100% yours and your own, unless you are in a group task that requires you to collaborate with other students. It is generally frowned upon for you to seek assistance, use the work or advice of other students due to academic integrity. And academic integrity is absolutely important. The university needs to know that it is your work that is being completed and your work that is being put forward so that they can generally grade you and ensure that you are learning and doing the best that you can, and without committing any of those types of things like plagiarism or copying other people's work. In the real world, collaboration is a lot different. Everybody is generally working together to achieve a single same task goal. Collaboration happens on a daily basis, meetings between clients, having superiors check over your work, edit it, and so on and so forth. Collaboration, interpretation, and generally coming together as a team to produce the work to do the best in the best interests of your client and of the firm happens every single hour of every single day in the real world practice. It is a lot easier to go and ask your supervisor if you're on the right track. Can they please check your affidavit and make sure that the facts are correct? You collaborate and look together and work very closely with your client to ensure that they're happy with the documents that you're producing and that they meet a certain standard. If you were to do this in the student world, academic integrity would be crushed. You would probably end up having an investigation for plagiarism, and there would be probably penalty applied for you having to collaborate and work together with a student. Whilst it is easy to get together in a study group and generally wrap your own ideas around it, unless it's in a group task scenario, you generally still have to make the work your own. In the real world environment, collaboration happens on a daily basis, and it is not hard to bring outside of your own practice to seek assistance from someone who's much more knowledgeable than you. Ask for precedent documents or any types of case files, or somebody might have already done that work to make it a lot easier for you to represent your client, or if there's something you may have missed. This is almost impossible to do when you're learning the law, and you must ensure that you're correctly referencing all of your materials to make sure that the person who's written them in the student world gets the academic accolades that they deserve. This brings me to the final fifth difference in relation to learning the law versus learning to be a lawyer, and that is accountability and mistakes. In the academic world, so long as you're not deliberately committing plagiarism, a mistake made falls back on the student. You'll be marked down, you'll get feedback, you can look at it and go, oh, that was pretty silly. And I can move on from there, make sure I don't do it again in the next assessment and learn from that mistake. Your mistake really only affects your grades and your GPA, and there is no real penalty other than that in the academic world. In the real world, accountability and mistakes can leave you open for disciplinary action, and you're liable for penalties and costs. There is plenty of case law out there where solicitors have been sentenced to jail, depending on their mistakes and their credibility being lost for really just committing fraudulent acts. You are held to a much higher standard in the community in the real world. You're expected to know what you are doing and not make a mistake. Whilst lawyers are human and sometimes things just happen, it is much easier to make the mistakes as a student. In the real world, I believe there's a real fear of making a mistake, and I, for one, was terrified of it during my placement. You hear all these different stories about employers letting solicitors go because they've made detrimental mistakes. But really, it's about accountability. If you can recognize your mistake, ask for assistance, and ensure that you do the best that you possibly can towards your client, generally mistakes are reduced. But I guess it goes towards intent. If you're intending to go out and commit fraud or make a mistake deliberately because you just don't care, then obviously you're leaving yourself open for disciplinary action and those sorts of penalties. But in the real world, you have to be accurate. It's not good enough to simply bungle your way through it, hit go on the assessment and off you go, and whatever your grade is, as long as you pass, adopt the attitude of P's get degrees and off you go. You must, in the real world, apply yourself in a much higher standard and aim for the most accurate and best outcome in the best interests of the client as you possibly can. It is not simply enough to just go, oh, oops, sorry, yep, won't do that again next time. In the real world, you're dealing with someone when your mistake could cost them everything. It's not just a monetary penalty. You're talking about people who might be facing jail time, and you could end up making their sentence worse. You could end up, causing them emotional harm and pain. And as I've said before, leave yourself open to disciplinary action. To be submitted to the Supreme Court is every law student's dream. You sit here and you go, oh, I can't wait for that day. And the reality is that it needs to be treated with the utmost respect and the utmost integrity. It is a massive honour to be submitted to the Supreme Court, to be able to work as a solicitor in a community. And I, for one, am excited and cannot wait. And I hope to be able to hold myself to the highest of standards and be a solicitor to the best of my ability.